The Code of Federal Regulations on due process complaints begins at 300.507. In general, a parent or a public agency may file a due process hearing on identification, evaluation, educational placement, or the provision of FAPE to a child. Any of those issues, both the parent and the school district can file for a due process hearing. Due process hearings must be filed within 2 years of the time that you either knew that there was a violation or that the school or agency should have known that there was a violation of the Individuals with Disabilities Education Act. Now, parents must be informed of any free or low-cost legal help that's available or advocacy help. Usually that's attached to the due process handbook. If you take a look in there, there's organizations listed such as Disability Rights Nebraska, or you can contact Legal Aid of Nebraska. Section 300.508 talks about what needs to be in a due process complaint. First of all, the other party has to be served a copy of the due process complaint when one is filed, and the party filing a due process complaint must forward it also to the State Department of Education. Under Section B, the content of the complaint, we've put what needs to be in the content of the complaint in here so you can take a look at it. The form that we have attached to here that you can link to, we ask you these questions and help you fill out the form. So we will ask these questions in that complaint form, and then it prints out and you can send it to both the school district and the State Department. You must send a copy of the complaint, the due process complaint, to the school district, otherwise there cannot be a hearing set. The school district has 15 days in which to say whether they agree that there's sufficient information in the complaint that they can respond. The hearing officer also looks at the complaint, makes sure that there's sufficient information inside the complaint in order to hold a hearing. If not, then a party may amend its due process complaint. Once the school district receives a complaint, they have 10, and they feel that it's sufficient, then they have 10 days upon receiving the complaint to send to the parents a response that includes an explanation of why the agency proposed or refused to take the action that is being complained about, a description of other options that the IEP team considered, and a description of each evaluation procedure, assessment, record, or report the agency used in order to make their decision to either do or refuse to do the action, and any other relevant factors involved. Section 305.10 talks about a resolution process, and of course this is prior to the hearing. So within 15 days of receiving notice of the complaint, then the school district can contact the parent and go ahead and have a meeting with the parent, which includes a representative of the public agency who has the authority to make the decision. And it may not include an attorney for the school unless there's an attorney brought by the parent also. And members of the IEP team are also involved in this meeting. And the purpose of this meeting is to try to come to some sort of conclusion prior to having a hearing and all that's involved in a hearing. If it's just a misunderstanding between the school and the parent, hopefully this meeting will solve that. This could be waived if both the parents and the school district agree, or if the parents and the school district go to mediation. If the problem is not solved within 30 days, then a hearing is set. If the school district is unable to get the parent to participate in the resolution meeting, then the hearing officer can dismiss the parent's due process complaint. If the school fails to hold the meeting, then we go ahead and set the due process hearing. Section C discusses when the timeline for 45 days to have a hearing, when that's initiated. If you and the school come to a written agreement, then here are the requirements on how the written agreement should be prepared. And if you do come to an agreement and you sign it and it's all taken care of, you still have 3 days in order to change your mind and void the agreement. Section 305.11 describes the impartial due process hearing. Here's the general requirements: that the state's responsible for conducting the hearing, that there are requirements for the impartial hearing officer, and this is at a minimum, that he can't be involved in the education or care of the child, that does not have a conflict with the case, possesses knowledge and ability to understand IDEA, must know how to conduct a hearing. Therefore, these are usually attorneys or somebody who's been involved in special education for some time, and must possess the knowledge and ability to render and write decisions. Issues that were not raised in the complaint cannot be raised at the hearing, so you can't have any new issues. They have to be set forth in your complaint. And once again, the event has to have happened within the last 2 years. And finally, here are some of the exceptions to the 2-year limitation. Section 300.512 sets forth your hearing rights. And what's listed here is you can be represented by counsel, or you can have an advocate there also, or you can represent yourself. Once again, I would encourage you at this level to have an attorney there. This is a court-like proceeding, but if you want to go ahead and do it by yourself, you can. You can present evidence and confront, cross-examine, and compel the attendance of witnesses. That is, you can have subpoenas. The parties are supposed to exchange all of their evidence at least 5 days prior to the hearing. Now, if they don't do that, then the judge can exclude that evidence. You can get a written record of the hearing. Here are the requirements of the 5-day rule that we just talked about and what the hearing officer can do. Parental rights at the hearing: the child may be present. The hearing can be open to the public, and the parent is provided a copy of the hearing and the findings of fact at no cost to the parents. Section 300.513 is on hearing decisions. The beginning here is all about how an administrative law judge goes about determining or making his decision. Section 300.514 says that the decision of the hearing officer is a final decision, that if you wish, you can appeal to the State Department of Education. They can do an impartial review of the decision and come back with a decision of their own. If the decision is reviewed by the state, once the review officer makes his decision, then that is also a final decision. And the reason you have a final decision is you need a final decision in order to access either state or federal court. Section 300.515 talks about timelines, that after the initial 30-day period, once a hearing is scheduled, the hearing officer has 45 days in which to render a final decision, and copies, of course, are mailed. If the decision is reviewed, then the State Department of Education has 30 days in order to complete their review, but extensions in that time period can be granted if you have a very complicated case that keeps going on and on and on. The 45 days may run beyond that. And finally, if you are dissatisfied with the decision, you can bring a civil action. It can either be brought in a state court or in a district court of the United States, which is federal court. So it can either be state or federal court. You should bring that within 90 days of the date of the decision of the hearing officer or the state review official. Section 300.517 talks about attorney's fees. Attorney's fees are available if you are the prevailing party. These are very complicated, so if you have an attorney can explain these to you. Section 300.518 talks about where your child should be while all of this is going on. Well, they should be in their current educational placement. This is almost always true. Some exceptions to this are if the school and the parents agree otherwise, that it's just not a good fit. Also, there are exceptions when there's some safety issues involved. Primarily, though, this is called what they call stay put provisions. And what that is your child should stay in their current placement with their current services until a decision is rendered. And that concludes due process appeals.